involved tax matters for Supreme Court and various high courts. He has been also appeared before the SSTEP, he was seated on the SSTEP. He has been appearing before that also. He is having a rich background in accounts and law, and also expert in customs and valuation, and very skillful drafter, I must say. He has been instrumental in assisting courts to decide various important court questions of law in indirect tax, and he delivered many lectures all across various prestigious institutions and non-profit bodies like us. With these few words, I present before you Shri Sridharan, and I request you all to welcome him to the round. I will request our President Part-3 to please offer a memento, which is well deserved. I will request Mr. Sridharan to please address us on the round.
We are all colleagues and no absolutely.
Which circular? Go for photocopy.
No problem. Friends, Rahul has victimized all of you, not me. The topic he has chosen, I think, is taken from the index of GPC, the interpretation of statutes. In fact, I sent a mail to him a few days ago. I request all participants to bring with them their copy of GPC. Okay. I specifically sent a mail to him and also told him to bring General Laws Act with you all. But I believe that he is not able to communicate to you all. And I am told they are all practicing chartered accountants. I don't know how many times you refer to that book, GPC's interpretation of statutes. You can read their practice. If you have not done so far, please develop the habit of that. Because one of the best books on the subject in the world. There is a story that, of course, Justice G.P. Singh just passed away about 3-4 months ago at the ripe age of 90. And he was the Chief Justice of Madhya Pradesh High Court for a full 8 years. He was never taken to the Supreme Court during emergency time because Indira Gandhi perceived too independent man. That's how judiciary functions. And whenever Lord Denning visits India, he makes it a point to go to Riva. Riva is a remote village in Madhya Pradesh where Justice G.P. Singh used to reside after his retirement. There are 2-3 books written by Indian authors or international. One is Palkava's Income Tax, C.Y.'s Constitutional Law, and this G.P. Singh's Interpretation of Statutes. I am not marketing that book, but certainly if you are not used to that book, it's a beautifully written book. And all principles on law you get there. In tremendous clarity, you can compare it with any of the best in the world. You may not read the first 50-60 pages, which lays down general principles of interpretation, which no judge ever follows. Golden rule of construction, strict rule of construction, etc. This is all only in theory. Every judge finds out his way of. But when he goes to the substantial portions, this is what we are going to discuss. Operation, experience, repeal of statutes, retrospective operation, etc. These topics really can be discussed for 7-8 days. So I have been given the task of discussing 1 hour. Okay. So I'll go at some speed. There will be no humor in the topic to the extent possible. Okay, kindly pardon me with that. Operation, experience, repeal of statutes, not operation, but operation, experience, repeal of statutes. Then second is retrospective operation, statute affecting litigation, consequence, experience, repeal, and temporary and perpetual statute. These are 5 topics only we will discuss. There are a number of topics on this. It's a very fascinating subject, and subject which is very close to my heart. And I have argued maybe on these very principles, it will have at least 10-20 cases, both in the Bombay High Court and Supreme Court. And it can be a powerful tool for a practicing lawyer. Sometimes, when you fall, when the patient is completely sick, no medicine can help. Surgical remedy is the only route. These are all tools which a lawyer requires to retrieve an impossible case. You will lead with it, and I tell you. Yes, come on. When do you say a statute commences? A law of the parliament comes into effect when the president assents it. Yes or no? A law of parliament assented by the president, not gazetted, what happens? Does it come into force? Question is clear? Law of Parliament, I am not talking about state legislation, I am not talking about a rule or a notification. Law of Parliament, assented by the president, not gazetted, it comes into force or not? Whosoever says no, put up his hand. It doesn't come. Who say yes? Rest all say yes. No use is no. No, that is not I there only in elections. Why do you say so, sir? Why it is not gazetted?
Through gazette only, the public would come to know that this is actually enacted and it has come into force.
Anybody else has a different view? Suppose the president assents it today, it is put in the gazette 2 months later. When does it come into force?
From the date
Put in the. He's a very tough lawyer. Good point. Yeah, somebody else said something else. Yeah. Acts of Parliament come into effect the day the president assents it. It need not be put in the gazette. Acts of Parliament come into force the day it is signed by the legislature. Acts of state legislature come into force from the day it is gazetted. There is a slight difference between Parliament and state legislature. Now, why both are independent legislative bodies? Why is the difference? Can you guess, sir? The state legislature comes into force from the day it is gazetted because generally State General Clauses Act says so. We have two General Clauses Act. One Central General Clause Act, General Clause Act 1890, and generally patterned on this central law, each state has also enacted the State General Clause Act in 1890s. All this happened in 1890s. Bombay General Clause Act, Madras General Clause Act, Bengal General Clause Act. Most of the General Clause Acts, when enacted when they were British provinces, they say as far as the provincial legislation is concerned, they will come in effect the day it is gazetted. There's a difference between central law and state law. And let me share it with you. I never knew the distinction till about 3-4 years ago. I thought all legislation come into effect the day the president assents and governor assents. That's the distinction between central law and state law. Okay? This one. Doesn't matter, sir. We cannot finish all the slides. Whatever we do properly. Okay. These two youngsters are in common law college. They have done everything and done a marvelous job. Okay. Gopal and Savio. They are all both young. They are all very young. After 30 years, I am not able to know all this. Good job done. The next question to you is, sir, the President of India has signed the Act at 6 p.m. Today is what, 7th of February. Suppose today is 11 o'clock now. Today is 11 o'clock. The President of India signed the Act today at this time, 11:25. Okay. Imposing sales tax or central excise duty at 15% on oil. Instead of 10%, 15% on oil. Let's assume that. A shopkeeper has sold the oil at 8 o'clock in the morning today, much 2 hours before the President has signed it. The old law was rate of tax on the oil is 10%. The new law signed by the President today at 11:25 is 15%. The shopkeeper has sold it at 8 o'clock. What is the rate of tax applicable on that? 10% or 15%? 10%. Who says 15, sir? Say, come on, sir. Why do you say so?
I say 10.
You said 10. What about you, sir?
15.
Why?
The day on which the president.
Sir, it is 11:25 only he signs it. 11:25 forenoon. The shopkeeper has sold at 8 o'clock. There is no way he will know the President of India is going to wake up from his sleep on a Saturday afternoon and sign. How do you do that?
That level of air-cooling is simply not done.
Not done. Why do? Then put it in the midnight of today 7th, no? Take to the midnight of 7th and 8th, no problem. You sign any time during the day, it will become law for the midnight of 7th, 8th. Whereas what you said is, it becomes law for the midnight of 6th and 7th. What you said is, it becomes a law when it is midnight of 6th and 7th. Whereas somebody else says it becomes law from midnight of 7th and 8th. The correct answer is, your answer is correct. It will become the law from the beginning of the previous day, the day it is signed. So the three things we need to know about commencement is only this. So it is irrelevant to make an inquiry at which part of the day the president assented it. It will come to 00 hours of that day. Not now. That's also brought in General Clause Act. These boys have put that slide very nicely. You know, the there. The right particular. Sir, if you see the second one, commencement of act may also be postponed related to specified order in the Gazette. You all know that. No? Section 1 will say this act we called Finance Act 2014. Subsection 2 will say this is act coming in effect from a date to be notified. We can say so. Sometimes it may not. If it is absent, what we discussed, it will come in effect from the date, provided the act does not say it will come in effect from a date to be notified. Subsection 2 will say. Once notified, it will be effective from that date. No, most sections will say different parts of the action can be notified at different dates. That is, section 4, 5 will come into force today, section 10 will come on another day, etc. That can be notified. One hand to argued for the court. So the facts are clear now. Section 1 says this act will be called Finance Act 2014. 1-2 says this will come into effect from a date to be notified. Okay. And then the notification is issued saying this act comes into effect from 1st of January 2015. So I argued, sir, you first have to notify 1-2. You have notified the rest of the sections. What he argued was, this act comes into force from a date to be notified. Right? Unless you first notify section 1, subsection 2, you cannot notify the rest of it. Therefore, it's a meaningless thing. You have done a wasteful exercise. What the argument was, the act comes into force to be notified. You say section 2 to 30 come into force from 1st January. Your first not said section 1, subsection 2 comes into force from this date and thereafter you can issue. That was the argument. What did the court say? Follow point, no?
Yes.
What did the court say? Court laughed. These are all academic exercises you can engage in your chamber. Laws are made for the purpose of implementation in the parliament. You don't make a dead letter out of it. Okay? Therefore, in section 1, subsection 2 says, this act will come into force from a date to be notified. That provision applies other than section 1. It applies section 2 to 30. Is it not so? The Lakshmana said, my brother used to give a beautiful joke. We are all taught in modern Jiva, in schools, 6 and 8. There is a village, it seems, which had a rule. The barber shaves everybody who doesn't shave himself. That's the rule. It's a very beautiful principle. The barber shaves everybody who doesn't shave himself. Who shaves the barber? Who shaves the barber? Huh? Himself. But the rule you violate. We say in mathematical sense, the operation performed in the set will apply to members of the set, not those who are outside the set. You know, in group theory, etc. also. It's very common as an example. So, when the proposition said, those barber will shave anybody who doesn't shave himself, he considers the rest of the village. Barber is outside the village. That's one example. Or he doesn't apply to himself. So, that's the same principle. When section 1, subsection 2 says, this act will come into from a date to be notified. It means rest of the section, not section 1 itself. Okay. This is to illustrate a point that sometimes the provision applies to the rest of the act and not to that very section itself, not for humoring ourselves to this particular example. Okay. We saw a funny case where the section was amended. The section says the act will come into from a date to be notified. Say, an act for Finance Act 2014, come into from a date to be notified. 1st January 2015 came. Then, hypothetically, let us say June 2015, an amendment is made retrospectively. Somebody argued, this retrospectively also can be notified from a date to be notified. Supreme Court said no. The duty to notify applies to this Act. When Amendment Act is made, that's the independent Act. That comes into the effect depend upon the language of that Act. If the Retrospective Amendment Act says it will come to effect when date to be notified, it's a different matter. The last point in this is, Act is made, assented by the President. Act itself says it will come into effect on 1st January. So it is signed by the President on 28th of December, 2014, to be effective 1st January 2015. Okay. When the Act comes on 1st January 2015, the Parliament wanted, government wanted Act also to be in place, rules ought to be in place. So they made the rules also on 28th of December 2014 to be effective from 1st January 2015. Facts are clear? Act passed, President signed, gazetted also. Okay? All renewed 28th December 2014. Act itself said this Act will come into force 1st January 2015. Along with the Act, rules were also framed, and that was made on 28th December 2014 to be effective from 1st January 2015. Are the rules valid? Very clear, sir?
Yes.
Yes. Come on. Rule valid or not? Invalid. Why, sir?
Act itself is not come on 20th December. So how rule can be made? This Act come into.
Anybody else has a different view? Other than you, sir. Anybody else? Come on, madam.
Same.
Same. What same?
What I felt is, you are the powers to give rules are in the section in the Act itself, and if your Act is not Act is not effective, you can also.
Good answer. Good answer.
Delegated legislation.
But then
First January.
you all are forgetting section 22 of the General Laws Act. Okay. Which specifically says in such cases the rules are not invalid. It will be valid till the day Act comes into force. Okay. You see, you are blaming the Parliament and the rule making authority that does everything, keeps it in place, and say if he gives you a surprise on the 1st January enacting the rule, then you cry, sir, we have no time to study the rule, understand the rule, implement the rule. If it does it in advance, also you blame. All lawyers do that. Section 22 of the General Laws Act takes care of that. This is one part. The more accurate answer is, there is a distinction between coming into force of the Act and commencement of the Act. There is a distinction between coming into force of the Act and the commencement of the Act. Alright. Let us take a different example. I said 28th December 2014 to be effective on 1st January 2015. Let us say the Act was made on 28th March 2014 to be effective 1st January 2015. 28th March 2014, effective 1st January 2015. The Parliament wants to amend this law between March 2014 to January 2015. Can they do or not? So they made the law, signed everything, March 2014 over, effective from 1st January 2015, they give you full 1 year time to read, understand, etc. As happened in Companies Act. They want to make the change. Are they necessary to wait till 1st January and then only carry out the amendment, or between March and January they can carry out an amendment? They can, because there is a distinction between commencement of the Act and coming to force of the Act. As the legislative body is complete, as the legislative body is complete, as the legislation is complete, be effective on this. You all heard of Higher Purchase Act 1972? To see you put higher purchase. We do the accounting difference between higher purchase, installment purchase. This is the Higher Purchase Act 1972. It has not been notified so far. There is an act which has never been notified. There are some problems in the act, it is contrary to common law. But Higher Purchase Act 1972 has been referred to in many laws, many other laws. Nothing illegal in that. It has not come into force, but as an act, it is made by valid Parliament, majority, resolution, etc. People have participated, not participated. That's all it is. Okay. Just anything else on this? Gopal, you want to say anything else? We have told them section 22.
Yes.
Just one last point. While this is the principle applicable to preliminary statutes, subordinate legislation, namely rules, etc., when do they come into force? There is no way subordinate legislation come into force on the day the Undersecretary signs and keeps in his drawer. No question. Harala's case, 1952 Supreme Court. Subordinate legislation to be effective has to be published in a reasonable manner. Unlike preliminary statutes, has to be published in a reasonable manner. What is reasonable manner will depend upon case to case. If the Act itself says rules will make a publication in the official gazette, that is generally as reasonable. Our Income Tax Act 295 says rules will be made by publication in the official gazette. Therefore, the Act prescribes the mode of publishing it should be done that manner, unless that mode is unreasonable. Suppose the Act of Madras says rules will be made in Tamil, published by beating of drums in Kashmir. That is an important point. There are subordinate legislations which affect the local area, need not be published in Gazette. It can be published in vernacular and local newspapers in that area. It can even be beating of drums, as used to happen to the voters. Marketplace, go and read. So, subordinate legislation come into effect not from the day it is signed by the Babu concern, from the day it is published. Manner of publication should be if provided in that method. Provided is not unreasonable. Subordinate legislation is a notification, subordinate legislation is obviously subordinate legislation. How is that? I was missing, I didn't see you. You are a regular in this, no?
Sir, higher purchase you said, it is referred in so many other.
Some other.
No, so that provision will be applicable.
Yes. It's been legislation incorporation.
Yeah.
It's legislation incorporation.
No, but when made act, that provision itself has not come into effect.
In other words, you will not be subject to the torture of the 72 Act. But if some other act, instead of repeating it, abbreviates it by pen and ink. Nowadays, with computers, where cutting and pasting is very easy, but those days it was not. So, in other words, an act which is enacted but not brought into force can also be referred to another statute successfully. No difficult. Again, too technical, sir? Sure, or too elementary? Oh. Because I am a trained lawyer, therefore I can complicate things.
Sir, if that the act which is referred in another act, if that is repealed.
Oh, again.
That also
You are well ahead of my times. Okay. Now, retrospective operation. You are all tax lawyers, no? So you must be fully aware of retrospective legislations. Huh?
We are only aware.
Only aware of it. You don't know of any prospective law only. You know only of retrospective law. In fact, you are making a tall, incorrect claim. Retrospective legislation, the king is UP sales tax law, not income tax laws. They are masters in that. Retrospective validation. Okay. There are two distinct principles involved in retrospectivity. One, what we call express retrospectivity. Parliament says, forget about Justice Kapade's judgment in Vodafone's case. I define, transfer, cite as by explanation retrospectively from 1961. I don't know why they restrict 1961, why they not done 22 Act. Sir, cite incidental question. 1922 Act was repealed in 1961. Is it open to the Parliament to amend today, retrospectively the 22 Act? Good. So who will amend it? All those.
Why there is a need to?
Oh, that's not your job, my job. All those who passed the act, they have to summon by from the Lord and say, come back and just do it. It is not a joke about this. State of Punjab and Haryana were combined state of Punjab. They got bifurcated into Punjab and Haryana. Then Haryana, the law of Punjab automatically applied to the erstwhile part, which was part of Punjab also, naturally. Many of the Gujarat laws, Bombay sales tax had continued in Gujarat till Gujarat sales tax was enacted in 1969. Many Bombay laws continue to be in this thing. Just as Contract Act made the British Parliament continues to apply to us. The laws when we are today Andhra and Telangana are bifurcated, so laws will be combined on. So one fellow argued, desperation only. So this law was made by Punjab legislature, so Haryana body cannot amend it. Then judge said, surely the Punjab and Haryana states will not unite together only for the purpose of amending this act and then bifurcate themselves again. So reported it. It's a constitutional thing. It is possible for the Parliament today to amend the 1922 Act also. No difficulty. That's the beauty of fiction. Let me take another example. Suppose Parliament does not have power to make income tax law. The income tax law can be made with state legislatures only. Okay. From 2000, income tax became a central legislation. Right? In 2012, Parliament wants to put retrospective income tax, assume, and that is valid. Let's assume it is valid. Can they put the income tax up to 2000 only, or they can put for 1990 also? Questions are clear, no? Parliament did not have power to make law related income tax prior to 2000. That was the state list. It came in part of the union list in 2000. An amendment is being made in 2000 to retrospectively impose income tax. Assume they are entitled to do it. There are some other challenges that become confiscated, ceases to be income tax, therefore violate Part-3 of the Constitution. That's a different matter. They have power to legislate an income tax from 2000. They are making a law in 2005. Levying income tax not only up to 2000 but for 1990 also. Is it valid? Valid or not?
Yes.
All of you, I am told sir, in our times in CA, there is an objective type of questions in all subjects. It was there for income tax also. Then after 1 year they removed it. I asked somebody, sir, in income tax for every question 2 answers are possible. So we both will correct, therefore we deleted objective type. So somebody therefore is merely saying yes and somebody says no. Or ask the juniors to say, sir, you will be able to give reasons for both. A good judge should be able to write 2 judgments in every matter. One dismissing the plaintiff or allowing the plaintiff. Or as Parasar sir used to say, Sridharan, you should not be like Abhimanyu, who knows how to get first of all is after you. You should be like Arjun. Go in and come out. What's the answer? Yes, why?
I don't have any power.
Yes. Come
The
on.
powers are given, so accordingly, retrospectively, anytime they can amend.
Absolutely. Yes, sir.
Estoppel can be by prospective.
Estoppel, no. Estoppel has nothing to do with the legislation. You clean the legislation. You will say tomorrow Constitution is in by Estoppel, Mr. Estoppel is for administrative law and sometimes delegate legislation, not against Parliament.
Powers from 2008, so cannot be done before that.
Why?
What is not within your power for a given period, simply because the list was amended and it came into another list, you cannot now make an amendment for a period where originally you had no
Which
power.
provision says Parliament has power to make law retrospectively? Is there anything in the Constitution that says Parliament can make law retrospectively? Is there any article in the Constitution that clause anywhere? None. The presumption, certain legal opposition world over is a clear legislative body can make law within its jurisdiction both prospectively and retrospectively. Therefore, we have to see when the power is exercised, not the period to which the law relates. What are you asking? In 2005, can government make a law related to income tax? Answer is yes. Second, is the power of the parliament to make law includes only power to make prospectively, or it also carries the power to make retrospectively? Answer is yes. That's all. Where is the third question? So therefore, the period for the extent is irrelevant. When is the legislation being made? That being so, the fact that 92 legislation, 1922 Act is repealed in 61 also makes no difference. You may separately challenge a legislation as oppressive, when you impose a tax retrospectively, that may be violating of Part-3 of the Constitution, fundamental rights. A challenge to the Act can be challenged on two grounds. Mr. State Government, you made a law related to income tax which you cannot make. That can be one ground. But even though state government has made a law, state legislature has made a law related to sales tax, you can say it is violating the fundamental rights and therefore one what we call legislative competence, other is Part-3 breach. There are two distinct breaches. There is a violation of Article 14, 19, etc. etc. And coming to your question of estoppel, etc. Normally tax is collected for the service the society is provided by the government. US Supreme Court took the view that you may tax retrospectively for past service rendered to you, which is followed by a judgment of the Supreme Court in Chota by case. Therefore, it is possible that Parliament can levy tax retrospectively also. They may choose not to do it, it's a different matter. So, once the law is made by the Parliament, retrospectively, yes, ma'am. Yes? Yes. Okay. I will just come to it a little later in 2 minutes. What I want to emphasize therefore here is, once the Parliament makes the law expressly retrospective, except you cry before the court in violating Part-3, you have no other remedy. No rule of interpretation is involved in it. There are two distinct parts. Law does not say it is retrospective. Then, court should not give an interpretation that makes it retrospective. That is the rule of interpretation or rule of construction. That is different from an express retrospectivity which Parliament has made. So we say, no, you increase the penalty from 100% to 200%. Section says penalty is 100% the tax is 200% the tax. Act decided about it. Will it apply to the past? Then you say, rule of interpretation, no provision should be made to be read retrospectively, so to increase the burden. That's the rule of interpretation. If two views are possible, one which does not make it retrospective should prefer to one which will make it retrospective. That's the rule of interpretation. That is different from express responsibility to the Parliament, challenge to that constitutionality. That is beyond us. That's what the Parliament rejects, except in the rare case you may say it's violated of Part-3. A statute deemed a retrospective which takes away or impairs the vested right, acquires the existing laws, or creates a new obligation, or imposes a new duty, or has a new disability in respect to transition already passed. Second point which these answers support is Parliament and state legislature have power to make the law retrospective. That's a different matter. The third point is different. First rule, can you all give from your experience an example where the court has held that this interpretation makes it retrospective, therefore that it will not be accepted? Any one example? Income tax court, there are so many cases. Any example? Think of. This interpretation makes it retrospective, therefore will not apply. Govinda's case? No. 77 Supreme Court, or the Reliance due depreciation. There is some controversy, our government is capable of saying depreciation carried for 100 unlimited time. Then in 99 introduced a provision, it can be carried for 8 years. 3 years later, withdraw this 8 years and again make it unlimited.
There is a special bench in actual agreement.
Special bench, they have a day after Gujarat project.
An SLB.
That's SLB what retrospective accumulated or understanding it. All these people also. They say in the Supreme Court, the old joke is, Mr. Shastri, what is gambling? Vishwanath Shastri was one of the most leading lawyers in the country, outstandingly brilliant lawyers. So the Supreme Court asked him, what is gambling? In the case about prize winnings act, etc., or lottery. Vishwanath Shastri says, what happened, my lord, in this court on Friday afternoons? Friday afternoon used to be SLPs those days. Govinda's case, under the 22 Act, liability of HUF cannot be recovered from the individual members. Under the 61 Act, liability of HUF can be recovered from the members. 61 Act. Question arose therefore whether assessment under the old Act done earlier can actually be done in terms of new machinery. You will see that, sir, case was on that. Govinda said, no, it's a substantial liability, section is silent, therefore you should not be interpreted to make it retrospective. Again, I am requesting you, please don't make the mistake I used to make for many years. When the section expressly says effective from 1961, you can't go and argue the court. My lord, this interpretation should not be allowed to make it retrospective. Said court of one case, you either get the amendment struck down on the ground of violation of Part 3 of the Constitution, that violates fundamental rights, Article 14, 19, etc. Or you make the astounding proposition, Parliament can make law only prospectively in this country. They don't know how to make law retrospectively. Both are equally astounding. Nobody is going to agree to either of this. That is different from, in Govinda's case, section simply says, 1961 Act simply says, members of HUF are also liable for the dues of the firm as HUF. And the section is silent, where it will apply for the past HUF. Then the court says, absent express retrospectivity, you don't have an interpretation which is making retrospective. Therefore, please say that this section enacted in 1962 will apply for assessment year 62-63 onwards. This is slightly different from your point. No, only the first year the assessment year will apply. That is slightly different. That applies for substantive provision, not for machinery provisions. Somebody then asked, I told you about this point, that you asked to judge the liability not the period when it relates, but when it is made. A constitutional judgment in 15 STC, Haji Abdul Shakur declared good sales tax, not declared earlier, declared goods, Parliament can take. Then somebody asked, sir, retrospective I told you, can you think of an act which only retrospective and not having any prospective operation at all? Normally you can have an amendment. An amendment can be prospective, as well as retrospective. The amendment can be accompanied with validation act or without validation. Amendment, only prospective amendment, prospective and retrospective, with other validation provisions. That's slightly different. Validation is different from retrospective. Can you think of only retrospective amendment without prospective amendment? It is possible. Suppose government wants to levy income tax only for the period prior to 2000, example, and don't want to touch the current body of citizens, and says those who earned income beyond 10 crores pre-2000, only on that amount is possible. It used to happen, for example, in wartime, both in the First World War and Second World War, while the vast majority of masses suffered, the business community due to scarcity, etc., had excess profits. We had got excess profit tax that you must have heard of. Excess profit tax at 1918, 1914, then excess profit tax 1945. Then it became business profit tax act, then it became companies tax act. That's what the whole sequence is. So you want to say those who made more than average profit during wartime, only on them you levy income tax. Or, as happened in district mining officer discourse case, that states levied a royalty on mining. Our Supreme Court said this is excise duty, state cannot levy excise duty, struck down. Facts are clear? Some mining royalty, states were merely levying and collecting it. It was struck down by Supreme India Cement's case saying it is excise duty and therefore states don't have power to levy excise duty, central law has the power to levy excise duty. And the states are forced to refund it. Then what did the center say? Center say, I make one line act. The following acts made by the state legislature shall be deemed valid and be made. So, center has the power and only for the cost up to 4/4/1991 only. So this is an example. District mining officer disclosed an example of a case which had only retrospective operations, no prospective operations. Anybody can tell me one other peculiarity of this example I gave you, discourse case? It's another beautiful example of initial legislation made by one body, subsequent legislation to another body. It also has a point on temporary statute. Time permits, we deal with it. I don't think we are going to have time. It's also beautiful general temporary statute. What is the effect of repeal of a temporary statute? Yeah. 1 minute. 3 July. The provoke means and validation and retrospect of 4 days. A completed assessment may be reopened, rectified if the relevant provisions are amended with appropriate prospective effect. Okay. I told you amendment, then retrospective, with or without validation. Can have competent validation, cannot have competent validation. It is nothing profound, sir. It's only a jargon. Just to impress people with so-called superior knowledge. There's nothing called this. Suppose the act is amended retrospectively to 1961. I happened in 80J, capital employed after Logan Machines judgment. Whether capital employed includes borrowed capital, includes borrowed capital was matter of dispute. Rule 19 of the income tax rule said we issued borrowed capital in capital and capital employed. Some high court struck down the rules beyond the rule making power. Then they put in the statute.